We begin this evening in Washington, D.C., where lawyers for former President Donald J. Trump have responded to special counsel Jack Smith's request for a protective order in the 2020 election case. Trump's team countered with a narrower protective order that would allow him to publicly discuss some of the evidence collected by the government ahead of the trial. The special counsel's office came back just hours later, urging Judge Chutkan to forego an additional hearing and sign off on the government's proposed protective order. Jack Smith's team said Donald Trump wants to try this case in the media rather than in the courtroom. And our friend Glenn Kirshner said it best last week. Judge Tanya Chutkan, she doesn't play. And we saw that tonight when she wasted no time responding at 9 p.m. on a Monday night, ordering to see both sides and getting them to agree on a time for a hearing on this protective order on or before this Friday. All this after the former president spent the weekend attacking the judge personally and the special counsel on his social media platform. Former DOJ official Mary McCord says all of this is just part of Trump's strategy.
I think this is really a delay tactic. Mr. Trump is now the defendant in an ongoing criminal proceeding, and they're treating this as though he is still just an ordinary citizen candidate whose rights cannot be restricted at all. And that's not the way it works in the criminal law. Rightly or wrongly, the law provides for on a showing of the requisite predicate cause, there can be restrictions on people. There can be restrictions on their liberty. Many defendants in criminal cases end up detained pre-trial. There can be restrictions on their speech. And I think that's something that Mr. Trump and his attorneys so far are not really acknowledging.
In addition to writing up that 29-page response, Trump's lawyers spent the weekend workshopping potential defenses, guess where? On TV. Here's how one lawyer, John Lauro, responded to a question about Mike Pence's testimony.
He said the president asked him to violate the Constitution, which is another way of saying he asked him to break the law.
He never said. No, that's wrong. That's wrong. A technical violation of the Constitution is not a violation of criminal law. That's just plain wrong. And to say that is contrary to decades of legal statutes.
Let's take a deep breath, because for fact's sake, we all learn in middle school civics that the Constitution is the law of the land, so a violation of the Constitution is, by definition, a violation of the law. Lauro also claimed that Pence's testimony would help Trump, saying that the former president would be acquitted if his vice president is called as a witness. But do not forget, Mike Pence is not the only former Trump official who could testify.
I have no plans to testify, but look, we'll always comply with the law.
Were you interviewed by the special counsel?
I'm not going to get into any discussion.
Would you appear as a witness if called?
Of course.
Of course. This is just one of the many legal proceedings the former president finds himself subjected to. Trump is potentially facing 7 trials before next year's election day, 3 civil, 4 criminal. Meanwhile, there's also news in the classified documents case. Today, Judge Aileen Cannon, who's overseeing that case down in Florida, has asked the Justice Department to explain its use of a D.C. grand jury in its continuing investigation.